Not a choice between someone else bringing the case and the law staying in place. And what we're really talking about, as Justice Sotomayor started this discussion, is who is the proper party to take out what isn't infected by the court's holding. With all these provisions where there may be no standing, one institution clearly does have standing, and that's Congress. And if Congress doesn't want the provisions that are not infected to stand, Congress can take care of it. It's a question of which side should the court say, we're going to wreck the whole thing, or should the court leave it to Congress?
We think the court should leave it to Congress for two reasons. One is the point I'm making now about justiciability, or whether the court can properly consider it at all. And the second is we think only a few provisions are inseverable from the minimum coverage provision. I just would like to —
Judge, before you go, Mr. Kneebler, I'd like your answer to Justice Breyer's question. I think you were interrupted before.
Yes. No. We believe that in that case, the tax provision should not be struck down. In the first place, the Anti-Injunction Act would bar a direct suit to challenge it. It would be very strange to allow a tax to be struck down on the basis of a severability analysis. Severability arises in a case only where it's necessary to consider what relief a party before the court should get.
Suppose there was a non-severability provision in this act. If one provision were to be held unconstitutional, then every single — someone would have to bring a separate lawsuit challenging every single other provision in the act and say, well, one fell and the Congress said it's a package, it can't be separated. That's your position?
The fact that such a clause might make it easy doesn't change the point. Article III jurisdictional problems apply to easy questions as well as hard questions. If I could just —
But there's no Article III jurisdictional problem, and Justice Alito's hypothetical that this is a remedial exercise of the court's power to explain the consequences of its judgment in this case.
But this Court has said that one has to have standing for every degree of relief that is sought. That was in Davis. That was Los Angeles versus Lyons.
Mr. Kneebler, don't you think it's unrealistic to say leave it to Congress, as though you're sending it back to Congress for Congress to consider it dispassionately, on balance, should we have this provision or should we not have provision? That's not what it's going to be. It's going to be these provisions are in effect, even though a lot of you never wanted them to be in effect and you only voted for them because you wanted to get the heart of the act, which has now been cut out. But nonetheless, these provisions are the law, and you have to get the votes to overturn them. That's an enormously different question from whether you get the votes initially to put them into the law. There is no way that this Court's decision is not going to distort the congressional process. Whether we strike it all down or leave some of it in place, the congressional process will never be the same. One way or another, Congress is going to have to reconsider this, and why isn't it better to have them reconsider it, what should I say, in toto, rather than having some things already in the law which you have to eliminate before you can move on to consider everything on balance?
We think as a matter of judicial restraint, limits on equitable remedial power limit this Court to addressing the provision that has been challenged as unconstitutional and anything else that the plaintiff seeks as relief.
But when you say judicial restraint, when you say judicial restraint, you are echoing the earlier premise that it increases the judicial power if the judiciary strikes down other provisions of the Act. I suggested to you it might be quite the opposite. We would be exercising the judicial power if one act was one provision was stricken and the other remained, to impose a risk on insurance companies that Congress had never intended by reason of this Court we would have a new regime that the Congress did not provide for, did not consider. That, it seems to me, can be argued at least to be a more extreme exercise of judicial power than striking the whole.
I think
I
not.
just don't accept the premise.
I think not, Justice Kennedy, and then I'll move on. But this is exactly the situation in Prince. The Court identified the severability questions that were briefed before the Court as important ones, but said that they affect people who are rights and obligations of people who are not before the Court.
Mr. Kneedler, move away from the issue of whether it's a standing question or not. Make the assumption that this is an issue of the Court's exercise of discretion. Because the last two questions had to do with what's wise for the Court to do, not whether it has power to do it.
Right.
So let's move beyond the power issue, which is your answers have centered on, and give me the sort of policy. And I know that's a bugaboo word sometimes, but what should guide the Court's discretion?
Well, we think that matters of justiciability do blend into I understand, blend into discretion, and in turn blend into the merits of the severability question. And as to that, just to answer a question that several justices have asked, we think that severability is a matter of statutory interpretation. It should be resolved by looking at the structure and the text of the Act, and the Court may look at legislative history to figure out what the text and structure mean with respect to severability. We don't
either. What happened to the Eighth Amendment? You really want us to go through these 2,700 pages? And do you really expect a court to do that? Or do you expect us to give this function to our law clerks? Is this not totally unrealistic that we're going to go through this enormous bill, item by item, and decide each one?
Well,
you don't have to.
Well, that is
Congress said was essential. Correct?
That is correct, and I'd also like to I just wanted to finish the thought I had about this being a matter of statutory interpretation. The Court's task we submit is not to look at the legislative process to see whether the bill would have passed or not based on the political situation at the time, which would basically convert the Court into a function such as a whip count.
And
that's
Mr.
not
Eden,
the Court's.
That would be a revolution in our severability law, wouldn't it?
It would.
I mean, we have never suggested that we're going to say, look, this legislation was a brokered compromise, and we're going to try to figure out exactly what would have happened in the complex parliamentary shenanigans that go on across the street and figure out whether they would have made a difference. Instead, we look at the text that's actually given us. For some people, we look only at the text. Should be easy for Justice Scalia's clerks.
I think that's.
I don't care whether it's easy for my clerks. I care whether it's easy for me.
I think that's exactly right. As I said, it is a question of statutory interpretation.
Well, how is that? What's exactly right? It's a question of statutory interpretation. That means you have to go through every line of the statute. I haven't heard your answer to Justice Scalia's question yet.
Well, I think in this case there is an easy answer, and that is Justice Kagan pointed out that the Act itself creates a sharp dividing line between the minimum coverage provision, the package of reforms, the minimum coverage provision along with the guaranteed issue and community rating. That is one package that Congress deemed essential.
How do you know that? Where is this line? I looked through the whole Act. I didn't read. Well,
it is in Congress.
Where is the sharp line?
It is in Congress's findings that the minimum coverage provision, without it, the Congress said in finding I, without that provision, people would wait to get insurance and therefore and cause all the adverse selection problems that gave rise.
That makes your case that the one provision should fall if the other does. It doesn't tell us anything about all the other provisions.
Well, I think it does, because Congress said it was essential to those provisions, but it conspicuously did not say that it was essential to other provisions.
May I ask you about the argument that's made in the economist's amicus brief? They say that the insurance reforms impose 10-year costs of roughly $700 billion on the insurance industry, and that these costs are supposed to be offset by about $350 billion in new revenue from the individual mandate and $350 billion from the Medicaid expansion. Now, if the $350 billion, maybe you'll disagree with the numbers, that they're fundamentally wrong, but assuming that they're in the ballpark, if the $350 million from the individual mandate were to be lost, what would happen to the insurance industry, which would now be in the hole for $350 billion over 10 years?
I mean, first of all, for the Court to go beyond text and legislative history to try to figure out how the finances of a bill operated, it's like being the Budget Committee. But we think the economists have added up the figures wrong. If there's Medicaid expansion, the insurance companies are involved in that, they're going to be reimbursed.
Well, what if there isn't Medicaid expansion? We've talked about the individual mandate, but does the government have a position on what should happen if the Medicaid expansion is struck down?
We don't think that would have any effect. That could be addressed in the next argument, but we don't think that would have any effect on the rest of the
So the government's position is that if Medicaid expansion is struck down, the rest of the act can operate.
Yes. It's in the past, Congress has expanded Medicaid coverage without there being. It's done it many times without there being a minimum coverage provision.
But I still don't understand where you are with the answer to Justice Alito's question. Assume that there is a substantial probability that the $350 billion plus $350 billion equals 7 is going to be cut in half if the individual mandate is strict. Assume there is a significant possibility of that. Is it within the proper exercise of this Court's function to impose that kind of risk? Can we say that the Congress would have intended that there be that kind of risk?
Well, we don't think it's in the Court's place to look at the budgetary implications, and we also.
But isn't that the point then? Why we should just assume that it is not severable?
No.
If we lack the competence to even assess whether there's a risk, then isn't this an awesome exercise of judicial power?
No, I don't.
To say we're doing something and we're not telling you what the consequences might be.
No, I don't think so, because when you're talking about monetary consequences, you're looking through the Act, you're looking behind the Act. Rather, the Court's function is to look at the text and structure of the Act and what the substantive provisions of the Act themselves mean. And if I could go past this.
Mr. Kneedler, can you give us a prior case that resembles this one, in which we are asked to strike down what the other side says is the heart of the Act, and yet leave in, as you request, leave in effect the rest of it? Have we ever — most of our severability cases, involve one little aspect of the Act, and the question is whether the rest. When have we ever really struck down what was the main purpose of the Act and left the rest in effect?
I think Booker is the best example of that. In Booker, the mandatory sentencing provisions were central to the Act, but the Court said Congress would have preferred a statute without the mandatory provision in the Act, and the Court struck that, but the rest of the sentencing guidelines remained.
I think the reason the majority said that was that they didn't think that what was essential to the Act was what had been stricken down, and that is the ability of the judge to say on his own what the punishment would be. I don't think that's a case where we excised the heart of the statute. You have another one?
There's no example. And
there is no example.
No, there's no example to our that we have found that suggests the contrary.
It's really a case of first impression. I don't know another case where we have been confronted with this decision. Can you take out the heart of the Act and leave everything else?
Well, I'd like to go to the heart of the Act point in a moment, but what I would like to say is this is a huge Act with many provisions that are completely unrelated to market reforms, and operate in different ways, and we think it would be extraordinary in this extraordinary Act to strike all of that down because there are many provisions and it would be too hard to do.
I mean, I think it's not uncommon that Congress passes an Act
And then there are many different titles, and some of the titles have nothing to do with the other titles. That's a common thing. And you're saying you've never found an instance where they're all struck out when they have nothing to do with each other. My question is, because I hear Mr. Clement saying something not too different from what you say. He talks about things at the periphery. We can't reject or accept an argument on severability because it's a lot of work for us. That's beside the point. But do you think that it's possible for you and Mr. Clement, I'm exploring this, to get together and agree on on a list of things that are, in both your opinions, peripheral? Then you would focus on those areas where one of you thinks it's peripheral and one of you thinks it's not peripheral. And at that point, it might turn out to be far fewer than we're currently imagining, at which point we could hold an argument or figure out some way, or somebody'd hold an argument and try to get those done. Is that a pipe dream, or is that
I just don't think that's realistic. The Court would be doing it without the parties, the millions of parties.
Have a conference committee report afterwards, maybe.
Yes. No, it just is not something that a court would ordinarily do. But I would like to
get back to the argument of the heart.
Yes.
Striking down the heart. Do we want half a loaf or a shell?
Right.
I think those are the two analogies.
Right. And I would like to discuss it again in terms of the text and structure of the Act. We have very important indications from the structure of this Act that the whole thing is not supposed to fall. The most basic one is the notion that Congress would have intended the whole Act to fall if there couldn't be a minimum coverage provision is refuted by the fact that there are many, many provisions of this Act already in effect without a minimum coverage provision. 2.5 million people under 26 have gotten insurance by one of the insurance requirements. $3.2 billion.
Anticipation of the minimum coverage. That's going to bankrupt the insurance companies, if not the states, unless this minimum coverage provision comes into effect.
There's no reason to think it's going to bankrupt anyone. The costs will be set to cover those amounts.
I thought that the 26-year-olds were saying that they were healthy and didn't need insurance yesterday.
Two and a half million people would be thrown off the insurance rolls if the Court were to say that. Congress made many changes to Medicare rates that have gone into effect for the courts to have to unwind millions of Medicare reimbursement rates. Medicare has covered 32 million preventive care visits by patients as a result of this Act.
All of that was based on the assumption that the mandate was constitutional. And if that certainly doesn't stop us from reaching our own determination on that.
What I'm saying is that it's a question of legislative intent, and we have a very fundamental indication of legislative intent that Congress did not mean the whole Act to fall if without the minimum coverage provision, because we have many provisions that are operating now without that. But there's a further indication about why the line should be drawn where I've suggested, which is the package of these particular provisions. All of the other provisions of the Act would continue to advance Congress's goal. It's the test that was articulated in Booker, but it's been said in Regan and other cases. You look to whether the other provisions can continue to advance the purposes of the Act. Here they unquestionably can. The broad public health purposes of the Act that are unrelated to the minimum coverage provision, but also the other provisions designed to enhance affordable access to affordable care. The employer responsibility provision, the credit for small businesses, which is already in effect, by the way, and affecting many small businesses.
Many of the people in Congress might not have voted for those provisions if the central part of this statute was not adopted. But to say that we're effectuating the intent of Congress is just unrealistic. Once you cut the guts out of it, who knows? Who knows which of them were really desired by Congress on their own and which ones weren't?
The question for the Court is Congress having passed the law, by whatever majority there might be in one house or the other, Congress having passed the law, what at that point is the legislative intent embodied in the law Congress has actually passed?
Well, that's right. But the problem is, straight from the title, we have two
complementary purposes, patient protection and affordable care. And you can't look at something and say this promotes affordable care, therefore it's consistent with Congress's intent, because Congress had a balanced intent. You can't look at another provision and says this promotes patient protection without asking if it's affordable. So it seems to me if you ask what is going to promote Congress's purpose, that's just an inquiry that you can't carry out.
No, with respect, I disagree, because I think it's evident that Congress's purpose was to expand access to affordable care. It did it in discrete ways. It did it by the penalty on employers that don't offer suitable care. It did it by offering tax credits to small employers. It did it by offering tax credits to purchasers. All of those are a variety of ways that continue to further Congress's goal, and most of all, Medicaid, which is unrelated to the private insurance market altogether. And in adopting those other provisions governing employers and whatnot, Congress built on its prior experience of using the tax code, which it is for a long period of time Congress has subsidized.
I don't quite understand about the employers. You're saying Congress mandated employers to buy something that Congress itself has not contemplated? I don't understand that.
No, I mean, employer coverage. 150 million people in this country already get their insurance through their employers. What Congress did in seeking to augment that was to add a provision requiring employers to purchase insurance or
based on the assumption that the cost of those policies would be lowered by certain provisions, which are by hypothesis, we're not sure, by hypothesis are endowed.
No, I think it's any cost assumptions about. There's no indication that Congress made any cost assumptions, but there's no reason to think that the individual market, which is where the minimum coverage provision is directed, would affect that. I would like to say I've pointed out why the other things would advance Congress's goal. The point here is that the package of three things would run contrary to Congress's goal if you took out the minimum coverage provision. And here's why. And this is reflected in the findings. If you take out minimum coverage but leave in the guaranteed issue and community rating, you will make matters worse. Rates will go up, and there will be fewer people covered in the individual market.
Well, if that is true, what is the difference between the guaranteed issue and community rating provisions on the one hand and other provisions that increase costs substantially for insurance companies? For example, the tax on high-cost health plans, which the economists' amicus brief said will cost $217 billion over 10 years.
Those are what Congress did not think of those things as balancing insurance companies. Insurance companies are participants in the market for Medicaid and other things.
But you're saying we have the expertise to make the inquiry you want us to make, i.e. the guaranteed issue, but not the expertise that Justice Alito's question suggests we must make.
Well, that's because I think this Court's function is to look at the text and structure and legislative history of the law that Congress enacted, not a financial balance sheet, which doesn't appear anywhere in the law. And just
you're relying on Congress's quite explicitly tying these three things
we do.
Together.
And it's not just the text of the Act, but the background of the Act, the experience in the states, the testimony of the National Association of Insurance Commissioners. That's the problem Congress was addressing. There was a shifting of present actuarial risks in that market that Congress wanted to correct. And if you took the minimum coverage provision out and left the other two provisions in, there would be laid on top of the existing shifting of present actuarial risks an additional one, because the uninsured would know that they would have guaranteed access to insurance whenever they became sick. It would make the adverse selection in that market problem even worse. And so in Congress trying to come up with a market-based solution to control rates in that market has adopted something that would work to control costs by guaranteed issue and community rating. But if if you take out the minimum coverage, that won't work. That was Congress's assumption, again, shown by the text and legislative history of this provision. And that's why we think those things rise or fall in a package, because they cut against what Congress was trying to do. All of the other provisions would actually increase access to affordable care and would have advantageous effects on price. Again, Congress was invoking its traditional use of the tax code, which has long subsidized insurance through employers, has used that to impose a tax penalty on employers, to give tax credits. This is traditional stuff that Congress has done. And the other thing Congress has done, those pre-existing laws had their own protections for guaranteed issue and community rating. Effectively, within the large employer plans, they can't discriminate among people. They can't charge different rates. What Congress was doing that in the other market. If it can't, that's all that should be struck from the Act.
Thank you, Mr. Kneedler. Mr. Farr.
Mr. Chief Justice, and may it please the Court. At the outset, I would just like to say I think that the government's position in this case, that the community rating and guaranteed issue provisions ought to be struck down, is an example of the best driving out the good. Because even without the minimum coverage provision, those two provisions, guaranteed issue and community rating, will still open insurance markets to millions of people that were excluded under the prior system, and for millions of people will lower prices which were raised high under the old system because of their poor health. So even though the system is not going to work precisely as Congress wanted, it would certainly serve central goals that Congress had of expanding coverage for people who were unable to get coverage or unable to get it at affordable prices. So when the government... One of
the points that Mr. Kneedler made is that the price won't be affordable because he spoke of the adverse selection problem, that there will be so fewer people in there, the insurance companies are going to have to raise the premiums. So it's nice that Congress made it possible for more people to be covered, but the reality is they won't, because they won't be able to afford the premium.
Well, Justice Ginsburg, let me say two things about that. First of all, when we talk about premiums becoming less affordable, it's very important to keep in mind different groups of people, because it is not something that applies accurately to everybody. For people who were not able to get insurance before, obviously their insurance beforehand the price was essentially infinite. They were not able to get it at any price. They will now be able to get it at a price that they can afford. For people who are unhealthy and were able to get insurance, but perhaps not for the things that they were most concerned about, or only at very high rates, their rates will be lower under the system even without the minimum coverage provision. Also, you have a large number of people who, under the Act...
Excuse me, why do you say I didn't follow that? Why?
Because
why would their rates be lower?
Their rates are going to be lower than they were under the prior system because they're going into a pool of people, rather than having some of whom are healthy, rather than having their rates set according to their individual health characteristics. That's why their rates are so high.
The problem, Mr. Farr, isn't it that they're going to a pool of people that will gradually get older and unhealthier? That's the way the thing works. Once you say that the insurance companies have to cover all the sick people and all the old people, the rates climb. More and more young people and healthy people say, why should we participate? We can just get it later when we get sick. So they leave the market, the rates go up further, more people leave the market, and the whole system crashes and burns, becomes unsustainable.
Well,
and this is not like what I think. What do I know? It's just what's reflected in Congress's findings, that it looks at some states and says this system crashed and burned. It looked at another state with the minimum coverage provision and said this one seems to work, so we'll package the minimum coverage provision with the non-discrimination provisions.
Well, in a moment I'd like to talk about the finding, but if I could just postpone that for a second and talk about adverse selection itself. I think one of the misconceptions here, Justice Kagan, is that Congress, having seen the experience of the states in the 90s with